I'll share my screen quickly and then we move on to the solutions for the exercise. Here we go. So there's a photo editing service which is called PixArt, which allows its users to edit their photos online and to put some kinds of customizable backgrounds. This has two plans, free plan and paid plan. The free plan has certain limitations on how you can use the service. Now, notice that in the drafting of the problem itself, we are giving away some of the things you might want to know about how people who build these websites distinguish between free and paid plans. And this is what is a key part of the commercial intent of the business entity. This commercial intent is what needs to be captured. And now when you meet somebody who says, I want terms of service and terms of use created for my website, you will say, okay, do you have a free plan? Do you have a paid plan? What's the difference in the users for that? Right? So that's how we've drafted the problem. We are not specifically asking you that what should the difference be between these plans, but we've kept this in mind while drafting the problem, that this kind of an idea is sort of transmitted to your head while you are reading these problems and performing the exercises. Okay. Now, so there are certain feature differences in the free and paid plan. The website also wants to use cookies to track customer behavior, to suggest what's the best kind of editing tools and backgrounds to use. Customers have an opportunity to have personal data removed. The website will have advertisement. One key commercial difference is the website will have advertisements in the free plan, third-party advertisements, because it wants to generate money, right? But it will not deal with any further interactions between the user and any third-party providers. And that's what it wants to exclude liability for. For the paid plan, then there is a separate scheme altogether where there are multiple usage formats that users can have. Users can use it for their personal use, commercial use, whatever they want. Now, the website wanted to ask you that in the paid plan, can it benefit from these Creative Commons images? That was the question that it wanted to ask you, right? So you had to choose which is the appropriate license and how that is governed. Now, I may refer to your solutions, or without referring to the solutions also, I may proceed in sharing some insights. Okay. So let's see. And I'll try to take solutions from people who are participating in the class, who are present in the class right now. Okay. Because that keeps this contextual, keeps it relevant. So the first is whether the feature, how to incorporate the features of the free and paid plans. That has to be done directly, which Praful has done correctly, right? He has said that what you will get in the free plan, what you will get in the paid plan. Okay. Then he moves on to the paid plan. Fine. The paid plan can be used for commercial use and Creative Commons license shall not be provided in it. Okay. Now, you need to specify, Praful, it's not about giving a Creative Commons license. It's about whether input images from Creative Commons license can be used or not. Now, if you see the link that we provided, okay, you did not have the Creative Commons license generator with you. There is a Creative Commons link for attribution of licenses. I'm just doing that on my screen and showing you. Okay. That link enables you to choose the version of the Creative Commons license that you are creating. So Creative Commons has multiple categories. You can monetize it, you may not monetize it. You can do a variety of things. So here it is. Okay. This is let me move this so that you can see. So you can see this site, creativecommons.org/choose. Now, anytime you're using images and literary works, Creative Commons is what you got to deal with. When you're dealing with software, at that time you will be dealing with MIT, BSD, GPL license, and Apache license. I had discussed those in the last session. But for content, we typically have the Creative Commons as a variation. Now look at this, okay? Selected license attribution for international. This is allowing commercial use. Now when I say no, look what happens. Selected license, sees the $ appears and there is a cross across it. Attribution, non-commercial, international. So you can choose what needs to be done. Right? Okay. Allow adaptations of your work, you say no. Let's see what happens here. One more variation. Equal to. If I say yes, that goes away. Okay. What's the variation called? No derivatives. So this is the Creative Commons license. Attribution, non-commercial, no derivatives for international. You have to cite this license, right? Because you're giving a standard term away. What is the use of these licenses? You can create, see, when you're the author of the work, you can create any license you want. But when you create this, when you use a Creative Commons license, you are following a standard genealogy or a origin method which is being used. So there are certain people, the other people who use your work, they can benefit from these terms and they can use it further on. As an artist, sometimes you will want that your work spreads around, right? So when you want that to happen, at that time you can decide what kind of royalty you want and what are the terms for the spreading around of such license. That's why you will do this. Otherwise, if I'm an artist who doesn't care, who wants to only care about my intellectual property in it and my right to commercialize it, I'll just make it private. I'll say copyrighted, no other license. But we are dealing with this because under these common licenses, artists have created a huge body of work. And that body of work can be used to benefit for the rest of us. Now, that's why we are using this. Okay. So our question here was that can you evaluate whether Creative Commons images can be used for this purpose or whether templates should not be provided at all in the paid plan from this license. Okay. Now, where you have a commercial use possible, you saw that there's a version here. You see here, allow commercial uses of this work. Okay.
Yes.
Now, if you say yes, allow adaptation, say no. Or you need this also yes. Okay. Why will you need this to be yes? Because the user is actually putting a photograph, no? When the user is putting their own photograph and using the website to find a new background and a new editing tool, that becomes an adaptation. So you'll need the adaptation to be shareable, otherwise there'll be a big problem.
Yeah.
Okay, for that user. So allow adaptations to be shared, allow commercial uses. This is the license. It will require this kind of attribution on the images, but this is the license that needs to be used by PixArt if it wants to use Creative Commons. This is a license that needs to be used for input. Plus, one more thing has to happen. It needs to find images which are compliant with this license. Otherwise, what will happen? There will be a breach by PixArt itself. Right? PixArt will breach the rights that it got. So say PixArt is mining into images from a Creative Commons library. Okay. Now that library has Creative Commons images, but different variations of the Creative Commons licenses exist over there. Now imagine what happens here is that some of the images say no commercial use of work allowed. Okay, this is the license that's there, and PixArt gives this out to the user in the paid plan. There will be a mess. PixArt will be violating its legal obligations. So it is a good thing that you have written it here that there will be no commercial use, but it is possible. Commercial use is possible for images which have this license. This specific license is needed for commercial use to take place. Okay. Now for this to happen, there has to be a business case that PixArt is able to find such images and filter them and segregate them. If it cannot do that, then what you've said is the best thing. Okay. But what you said is about the output, that images will not be given in the Creative Commons license, which means a user cannot create a Creative Commons license. But that's not necessarily up to PixArt. What you want PixArt to decide is whether as an input a Creative Commons license can be used, whether a Creative Commons image can be used for the purpose, or whether templates should not be provided at all in the paid plan. So this is the question that needs to be answered. Now you understood how it can be answered?
Yeah, got it.
Okay, great. Now the business owners want advice. Should they integrate their product with another website? Draft a suitable clause which communicates the terms of such integration in a legally valid way. How do you do this? So you need to look at terms and conditions of websites such as iStock Photo. Okay, so there is Getty Images, iStock Photo. Now what you need to look at is what is the kind of use you can do. Is there a limitation on whether you can do commercial use or not of those images? The materials may only be used for your own non-commercial, personal or educational purposes. Any website which gives you images under this, you cannot use for your paid plan, right?
Yeah.
Because you are making money by doing this. Let's look at Getty Images terms of use. So this is how PixArt will have to decide that which image and which image can I actually provide. So it says you have to use Getty Images content on a embedded viewer. You cannot use it for a commercial purpose. Any content which is an embedded Getty Images content. We want to see Getty image itself, not the content. Just hang on 1 second. Let me look at the other license. Why I'm taking you through 2-3 is that when you decide a business model and a formula, an entrepreneur can come to someone who's skilled in legal aspects at any point in time. This will count. So here Getty Images says Getty Images is a paid license you get. So they offer 3 kinds of license: royalty free, rights ready and rights managed. Royalty free means there's no cost, license fees paid once and there is no need to pay additional royalties if the content is reused. Rights managed and rights ready content is for specific use only, and pricing is based on factors, many factors. So rights managed and rights ready you can't use from Getty Images. Royalty free you can use. Now let's see what's the restriction on commercial use. You may not use content marked editorial for any commercial uses. Otherwise you can use. Let's look at something else. Do I need to include? You do not need to include a photo credit for commercial use, but if you are using content for editorial purposes, you must include the following credit. Which means I can use it for commercial purposes unless it is editorial content. Which content can I use for commercial purposes? Royalty free, not rights managed, and not rights. What is the other one? Rights ready. You can't use these content. You'll have to look at their terms if it's rights ready and rights managed and see if commercial use is allowed. But for royalty free content, it is allowed. So this is how you will let them know. Otherwise, you will tell them that if nothing is available, that boss, use your own backgrounds, create your own backgrounds, get your own photographers, ask them to click images and upload. Or have your own artist community. Okay. The other aspect I wanted to address for the problem was, so arbitration is clear for you. Let's look at privacy and usage of cookies first. Okay, privacy is privacy policy. So what is the SPDI rules actually say how to protect data, Praful.
Yeah.
So that needs to be specified. A reference always is not sufficient. Okay.
Okay.
So try to identify which are the standards and then how will it work. Okay, so this is a good arbitration clause. You have excluded oral hearing. You have said there will be fast track procedure. Award will be passed in 60 days. What about number of arbitrators? You have not mentioned the number of arbitrators.
Not mentioned here because it is on the PixArt. In the top, I have mentioned as per PixArt. Otherwise, if you don't agree to these terms, you are not allowed to use the license.
Yes, but there may be 1 arbitrator or 3 arbitrators. So how many?
That I have not mentioned. Yeah, that I have not mentioned.
So we need to specify that, because if this goes to court, you don't want any kind of doubt on this. Okay. Then who can be your arbitrator? Now you saw what kind of discussion we had. This was a very highly IP heavy discussion on commercial terms. Okay.
Yeah.
So now here you need to specify what kind of arbitrator can be there. If you don't do that, then you may have an arbitrator who's a judge but who has never done IP matters, or who does not have an experience in open source related work. So you need to have, you could specify, for example, that there will be a sole arbitrator who has been an IP lawyer for the past 5 years and who has done some work on open source licensing. I'm giving you an example. Or who has advised internet companies as a lawyer on documentation. Okay. Now, if you say that, and then you say that the fees of the arbitrator is going to be as per the 4th schedule of the Arbitration and Conciliation Act, then it will make a difference.
Yeah.
Why? Because the arbitration clause becomes very tight, right?
Yeah. Yeah. Got it.
And let's look at how you're obtaining consent. So there's this question, right? This is a bonus question. How should consent be obtained for EU users, and what additional steps should be taken to ensure the website is GDPR compliant? Did you have the opportunity to do this, or did anyone else in the class do this exercise?
I read the content but couldn't incorporate, but the time was, I was behind time.
Okay. Now, so if you read the content, then tell me, how should this be GDPR compliant? Let's have a conversation.
They have not sort of, the European Union has not come out with the guidelines, but there is some interactive, I have mentioned that ISPR rules, IPRS rules will be followed in EU. And they are still...
Not mentioned?
Pardon me?
Which guidelines have not been there?
That IPRS, because they have not finalized the GDPR guidelines which have to be incorporated. They are in the process of finalizing it.
No, but GDPR guidelines are finalized. They are very clear. GDPR guidelines say that you have to take consent and you have to take informed consent. Okay?
Yes.
And that means that you can only, you need to very clearly take consent of the user. You need to say which is the purpose for which you will be using the data. So if I take consent of the user for marketing for educational products, I cannot market a product which I have not taken consent for. So like if I am a Google or a Reliance and I take consent for Gmail, doesn't mean I have consent for Google Maps. Unless I have a specific clause which says I will use this for Google Maps. Now if I have that clause, it needs to be clearly visible to the user that this is what I will do. I cannot tuck it away under fine print. I cannot say I accept without making the user read it. So some of the things that can be done, like Apple does it very well, is that it makes you click on I accept, but before that you have to click on it, open the terms, and then you can still not click on it unless you go till the bottom.
Yeah.
So that kind of a thing needs to be done. Otherwise, this will not be GDPR compliant.
Okay.
So I have sent you a link. Now we will embed this content inside the course. This is a very simple link which says how to collect customer data and how to take their consent for it. Okay. One thing you must keep in mind is that you want to provide, let's say, an online product or online educational course. So you have to collect data which is only reasonable and relevant to the service you are providing them. And you need to tell them how this will be processed. If you're taking information about their blood group, for example, and you are only selling food items or you are selling them an educational course, this is not going to be relevant at all, right? So this is not data necessary for the purpose of the service you're providing them. So your data you capture needs to be necessary to the purpose you're providing them. And you need to say to the customer that how it will be used. If you're going to share data with somebody else, you will need to tell the customer that I will share your data with this company. Okay. So keep that in mind.